This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, you have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No.
They're just alleged aggravators.
Correct.
And the grand jury never found probable cause for them.
Correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
That's what I said.
Okay. Hold on one second.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases. I know in capital cases they call it a CONUS hearing, but this is for non-capital case.
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination.
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty. For example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreaux. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay?
All right. 13.5b talks about amending the charge or the indictment. Okay. Your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole other allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause finding.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge, with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for, it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find...
They didn't find these specific aggravators being a dangerous offense, and these specific aggravators
what I said,
are different,
what I was saying?
right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation, all right? You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So,
No dangerous instrument or deadly weapon was used.
so because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you, all right? There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay, before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct,
before trial starts.
because you're not entitled to one.
Okay.
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
This is not an amendment of the indictment?
It's not. There's a difference
It's an
between,
extension of the indictment. It's not in the indictment.
it's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
That's
aggravators,
exactly my point. After the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
probably nothing in reality. You just said it. They don't change the charge, so you're not entitled to a probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can not.
How are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Okay. Well, if you don't want to attend, you don't have to attend. What else?
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and there's
they
no
can't
more
do-
available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then, is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time?
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay. I have one more issue.
Go ahead.
Okay. Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that, so how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay,
All right? Anything else?
that was it.
All right, we'll see everyone.
She said, if both parties can use all the jury food, that also means that we can bring in the survivors whatever time tomorrow, since they haven't put out a message yet, or excuse everybody.
Okay, so I'm being informed that the jury commissioner said if the parties stipulate to not bringing in any jurors tomorrow, we can do that. Remember last time, though, we screened whatever number we had. A few of those people didn't show up, even though they were informed they needed to show up. So we have 66. I think because it's a shorter trial, we don't necessarily need 4 alternates, but maybe we should just in case. I don't know.
Judge, I would still want 4, given that we lost
We
2 in
lost-
the first 2 days.
We did.
I don't want to waive any appeal issue that it wasn't random for whatever reason. I didn't understand your total reasoning, but how it's saying like the county by county or something, or
No,
section by section?
The theory is that there's
One county. But
maybe certain demographics of people, and I don't know who it is, that wouldn't respond to an email or online, or they think it's a scam, so they want to show up at the courthouse to do their jury service. Or maybe they don't have access to the internet to begin with. So the theory is that you're missing some sort of group of people that aren't responding remotely and instead would show up